The mediator asked about the 4-week offer. My lawyer said that wasn't consideration. My contract guaranteed 24 weeks. 4 weeks represented a reduction of existing rights, not a new benefit. The mediator asked if the company wanted to make a settlement proposal. Their lawyer said 4 weeks remained available. My lawyer said we were seeking full contractual severance, 24 weeks plus legal fees incurred to date. The mediator called a 30-minute recess. We reconvened at 11:15. The company offered 8 weeks. My lawyer countered at 24 plus costs. They offered 12. We countered at 22 plus costs. They offered 16. Final. My lawyer muted the video. Asked what I wanted to do. I considered it. 16 weeks was 2/3 of my contractual entitlement, but arbitration would take months, cost more in legal fees. Outcome wasn't guaranteed. I'd already accepted another position. I didn't need vindication. I needed closure. I told her to counter once more. 20 weeks, no legal costs. She unmuted, made the offer. The company asked for a 15-minute break. When they returned, they accepted. 20 weeks of severance, mutual release, payment within 14 days. The mediator drafted the settlement agreement. Both sides reviewed, both sides signed. The hearing ended at 12:30. I closed my laptop, sat in silence for several minutes. It was done. 2 weeks later, the payment cleared. 20 weeks of my previous salary. I started my new job the following Monday. Different company, different team, different office tower, same industry. I didn't mention the severance dispute during interviews, didn't reference the mediation. It wasn't relevant. My new role was similar, managing analytics. Smaller team, different clients. The work was good, the culture was better. 6 months passed. I attended an industry conference, Financial Services Risk Management, 2-day event at a hotel near Orchard Road. I was speaking on a panel about portfolio optimization. The CFO from my previous company was on the same panel. He didn't acknowledge me before we went on stage, didn't make eye contact during the discussion. Afterward, he approached me in the hallway near the conference rooms. He said he'd heard I was doing well at my new company. I said I was. He said the restructuring had been a difficult period. They'd had to make hard decisions. I said I understood. Business decisions sometimes had consequences. He paused, then said they'd revised their separation agreement template since then, made the language clearer. I said that seemed prudent. He nodded, walked away. 1 year after the settlement, I heard through a former colleague that 2 other managers from the restructuring had filed claims. Both had contacted my lawyer. Both reached settlements. 18 months later, I was promoted. Director of Analytics, 30-person team, broader portfolio, better compensation package. I reviewed my new employment contract with great care, read every clause, asked questions about ambiguous terms, negotiated 2 changes before signing. I kept copies in multiple locations, 1 at home, 1 in my office, 1 in encrypted cloud storage. I also kept the settlement agreement from my previous employer, the mediation notes, the payment confirmation, my original employment contract with the relevant clause highlighted. Not because I expected to need them again, because some documents serve as proof of exactly what you're worth.
The resignation was labelled voluntary. The severance payment showed $0. The exit interview form said mutual agreement to part ways. My name is Victoria, and I'd managed the analytics division at the financial services company for 6 years. 18 people reported to me. Revenue forecasting, risk modelling, client portfolio optimisation. The restructuring announcement came on a Thursday. My department was being consolidated. My role was redundant. Last day would be in 2 weeks. The HR director handed me the separation agreement. 3 pages, standard release language. Section 4 stated, "Employee acknowledges this is a voluntary resignation. No severance payment will be provided." Section 7 stated, "Employee confirms they have not been constructively dismissed or forced to resign." I read both sections twice. Then I opened my employment contract, the original one, signed 6 years ago when I joined. Clause 12. In the event of position elimination or redundancy, employee is entitled to 12-week severance plus 2 weeks per year of service. I'd worked there 6 years. That meant 24 weeks of severance. I checked the restructuring memo again. Position eliminated due to organisational changes. Redundancy. The separation agreement said voluntary resignation, 0 severance. Both documents came from the same executive, same legal department, same week. I placed them side by side on my desk. Then I opened my laptop and started a new folder. I labelled it Employment Documentation. I saved my employment contract, the restructuring memo, the separation agreement, every performance review from the past 6 years, all rated exceeds expectations or outstanding. Then I exported my calendar. Every meeting for the past 12 months, every project milestone, every client interaction. I backed everything up to 3 separate locations. I didn't sign the separation agreement. Friday morning, HR sent a reminder. The agreement required my signature by Monday, otherwise my departure would proceed without documentation. I read the email twice. Didn't respond. The weekend passed slowly. Monday morning, I arrived at the office at 8, 7th floor, corner office overlooking Marina Bay. My team was already there. Morning stand-up at 9. I ran the meeting the same way I always did, reviewed the week's deliverables, assigned new tasks, answered questions about client requests. Nothing had changed, except everything had. At 10:15, the HR director appeared at my door. She asked if I'd signed the agreement. I said I was still reviewing it. She said it was straightforward, standard separation language. Most people sign these without issue. I said I'd noticed the agreement described this as voluntary resignation. She said that was correct. I said my employment contract referenced severance in cases of position elimination. She stopped, then said she'd need to check with legal. I said I'd wait. She left without another word. I went back to work, reviewed a client risk assessment, approved 2 reports for distribution, responded to 14 emails. At 3 p.m, I received a calendar invitation. Meeting with legal, Wednesday at 2. I accepted it, added a note to my personal calendar. Tuesday was quiet. No one from HR contacted me, no follow-up from legal. I worked through my normal queue. My team operated as usual. projects stayed on schedule. I documented everything. Every task completed, every decision made, every client interaction. Wednesday arrived. At 2 p.m, I walked into the large conference room on the 8th floor. The HR director was already seated. A corporate lawyer I'd never met sat beside her. The CFO sat at the head of the table. The lawyer introduced himself. Senior counsel. He said they'd reviewed my questions about the separation agreement. He explained the restructuring was being administered as a voluntary separation program. Employees were choosing to accept the elimination of their positions rather than being involuntarily terminated. I asked how that differed from redundancy. He said redundancy typically implied the company was forcing the separation. This was a mutual decision. I asked if my position was being eliminated. He confirmed it was. I asked if I had any choice about whether my position was eliminated. He said no. The restructuring decision was final. I asked how my departure could be voluntary if I had no choice about my position being eliminated. He said the voluntary aspect referred to my acceptance of the terms. I said my employment contract entitled me to severance when my position was eliminated. The contract didn't distinguish between voluntary and involuntary. He said the contract language was ambiguous on that point. I said elimination was elimination. The contract was clear. The CFO spoke for the first time. He said they were prepared to offer a compromise. 4 weeks of severance, as a gesture of goodwill. I asked if that meant they acknowledged my contract entitled me to severance. He said they were offering it voluntarily, not as a contractual obligation. I asked what would happen if I declined their offer. The lawyer said my last day would remain Friday as scheduled, with no severance. I said I needed time to consider. The CFO said I had until Thursday. The meeting ended at 2:43. I returned to my office, opened my documentation folder, added typed notes from the meeting. Then I researched employment lawyers in Singapore. That evening I contacted 3 firms, sent each one my employment contract, the separation agreement, and the restructuring memo. 2 responded by morning. 1 said they couldn't take the case, conflict of interest. They represented my company on other matters. The other wanted to meet. Thursday at 11. I confirmed. Thursday morning I met the lawyer at her office. Small firm, 3rd floor of a building near Raffles Place. She'd reviewed everything I sent. She said my contract was unambiguous. Position elimination triggered severance. The company couldn't avoid paying by labelling the separation voluntary. I asked what my options were. She said I could file with the Ministry of Manpower, pursue private arbitration, or negotiate while threatening legal action. Most companies settled rather than litigated employment disputes. I asked her to draft a demand letter. She said she'd send it Friday morning. I thanked her, signed a retainer agreement, left. That afternoon, HR sent another reminder. I had until end of day to sign the separation agreement. I didn't respond. Friday morning at 9, my lawyer sent her letter. To the company's legal team, copied to HR and the CFO. The letter stated I was rejecting the separation agreement. My employment contract clearly entitled me to 24 weeks of severance. The company's characterization of my departure as voluntary was inconsistent with the facts of position elimination. Unless the contractual severance was paid, I would pursue all available legal remedies. I didn't go to the office Friday. I worked from home, answered emails, responded to my team's questions, completed a client analysis. At 4:18, the HR director called. She said today was my last day. I needed to return company property. I said I hadn't agreed to resign. She said my position had been eliminated. I said correct, which triggered severance under my contract. She said severance required signing the separation agreement. I said the agreement contradicted my contract. I wouldn't sign it. She said without my signature, my employment would end today with no severance. I said I looked forward to arbitration. I ended the call. Saturday morning, I received an email. Termination letter, effective Friday, position eliminated, no severance paid. I forwarded it to my lawyer. Sunday, I reviewed 6 years of documentation, performance reviews, project records, revenue my team had generated, client retention numbers. Everything was backed up. Everything was organised. Monday, my laptop access stopped working. Email account deactivated. Building card declined at security. I spent the day organising files, creating a timeline, documenting every interaction since the restructuring announcement. Tuesday, my lawyer filed a notice of claim with the Ministry of Manpower. Unfair dismissal, breach of employment contract, failure to pay contractual severance. The company had 30 days to respond. I started looking for new work, updated my resume, reached out to former colleagues, applied to 3 positions. By Friday, I had 2 phone screens scheduled. Week 2 began quietly. The company's response arrived Tuesday. Their legal team denied all allegations, stated the separation was voluntary. I'd been offered reasonable terms and declined them. No severance was owed. My lawyer filed a detailed reply, attached my contract, the termination letter, the restructuring memo showing position elimination. She highlighted the contradiction. The company couldn't claim I voluntarily resigned while simultaneously stating they eliminated my position. Week 3, I had 4 interviews. 2 went well. 1 led to a second round. Week 4, the ministry scheduled a mediation hearing, 5 weeks out. Week 5, I received a job offer. Different financial services firm, similar role, slightly lower base salary but stronger bonus structure. I accepted. Start date in 4 weeks. Week 6 was quiet. I prepared for mediation, reviewed documents with my lawyer, practiced responses to likely questions. Week 7, 3 days before the hearing, I received a call from one of my former team members. She asked if I was really taking the company to arbitration. I said mediation first, arbitration if needed. She said 2 other senior managers from the restructuring had been pushed out the same way. Same separation agreement, same 0 severance. Both had signed rather than fight. She said she wished someone had challenged it earlier. I said I was challenging it now. Week 8. The mediation hearing was scheduled for Wednesday at 10. Video conference. My lawyer, the company's legal team, the HR director, a government mediator. The mediator opened the session, outlined the process, asked each side to present their case. My lawyer went first. She walked through my employment contract, Clause 12. Position elimination triggers severance. 12 weeks base plus 2 weeks per year of service. 24 weeks total for 6 years of employment. She showed the restructuring memo. My position was eliminated. The document used the word redundancy. She showed the termination letter. Position eliminated. The company had eliminated my role, not requested my resignation, not offered alternative positions. Eliminated. The separation agreement tried to recharacterize this as voluntary resignation, but the facts didn't support that characterization. Either my resignation was voluntary, meaning my position still existed, or my position was eliminated, meaning severance was owed. The company couldn't have both. Their lawyer responded. He argued the separation agreement constituted new terms. I'd been offered an opportunity to separate on agreed terms. I declined. My lawyer countered immediately. She said a separation agreement can't override existing contractual rights without valid consideration. I'd received no benefit for waiving my severance entitlement,